So just by way of formalities, my name is Jason Sprague. I'm a partner in the corporate commercial group here at Bardia Perry. Thankfully, I'm just the window dressing for tonight, just introducing our speakers and giving a brief overview of what we're here for. But before we start, I'd like to do the acknowledgement to country, and I acknowledge the Gadigal people of the Eora Nation, traditional custodians of this land, and pay my respects to the elders past, present and emerging. So welcome to Bardia Perry. It's a lovely sunny day outside, so what better way to introduce a topic of sunscreens than a lovely, nearly summer's day. Now, when someone says, let's get ready for summer, I must admit, I think more, where's my cricket bat, where's my beach towel, rather than sunscreens, are they a therapeutic good or a cosmetic? That being said, it's a very important question. We love the outdoors, we're always very conscious of taking care of our skin. The old, I think it's still around, the old slip, slop, slap campaign that was around, well, even since I was a kid, that was a long time ago, tells you to look after your skin. We have the highest rate of melanoma in the world. So quite clearly sunscreens are an important part of our lives, particularly in the summer, when we all want to be outdoors. So we are looking today at sunscreens as a product in terms of how they might be viewed under the Therapeutic Goods Act and whether they can be a cosmetic or something which is therapeutic. And also we're looking at how the law might apply in terms of your marketing of those products under the Australian consumer laws. So our speakers today are Ellie Kim from RFA Regulatory Affairs. Ellie will be speaking first, and she has quite an extensive bio with a very impressive list of accomplishments. Got a Bachelor of Medical Science, a Bachelor of Health Science in Chinese Medicine, and a Master in Herbal Medicine with honours. She's been with RFA since 2012, and she'll be looking at the TGA aspects of sunscreens today. Michael Cassetto will be speaking second, and he'll be looking at the Australian consumer law and giving an overview of the legal framework as it might apply to the marketing and sale of sunscreens. Michael is a partner at Bardia Perry and the head of our corporate commercial group. Now, we are still in November, which means it's still Movember, and you'll see when Michael speaks, he's still rocking his moustache and goatee quite proudly. So if you haven't already sponsored a Mo Bro or Mo Sister, then you still can. And of course, Movember is a very important cause for men's health, particularly around prostate cancer, mental health, and suicide prevention. So if you haven't done it yet, I suggest that you do. Now, a bit of housekeeping. Mobile phones, please put those to silent and vibrate. And in terms of questions, we'll hold those to the end. We have had some pre-questions come in, but hopefully we'll answer those during the presentations. If not, we will look at answering those at the end of question time. Now, for those of you of my sort of age group, did you ever watch RoboCop? There's one yes that came out there. I heard it. It was very quiet. Yeah, it was me. But I've always remembered this for some reason. I don't know why. I thought I'd share it with you.
They say 20 seconds in the California sunshine is too much these days, ever since we lost the ozone layer. But that was before Sunblock 5000. Just apply a pint.
Cosmetic perhaps? I don't know.
Your body, and you're good for hours. See you by the pool. Sunblock 5000. Protection for the new age.
Yes, frequent use will cause skin cancer. Well, possibly therapeutic good perhaps. I don't know. But on that note, pass to Ellie Kim to talk about Australian sunscreen regulations and the TGA. Thank you, Ellie.
Hello, that's quite a scary product that we just sold. Okay, good afternoon everybody, and thanks for coming, and thanks to Bardia Perry for this event this afternoon, or is it close to evening now? So today I'm going to talk about the regulatory requirements for the sunscreens in Australia. So to talk about the sunscreens and how they are regulated in Australia, it's actually it will be important to sort of note this particular slide where the different regulations are and then where the product may fall within these categories. So what you would note is that there are obviously cosmetic products that's regulated by NICNAS in Australia, and then there are therapeutic goods that's regulated by Therapeutic Goods Administration. And then there are foods that's regulated by Food Standards Australia and New Zealand. What I would like to sort of draw your attention to is that how there is an overlap between the cosmetics and therapeutic goods, and especially complementary medicines, and we're probably talking about the ones that's applied topically on your skin, and that obviously includes sunscreens too. And also there's an overlap between foods and medicines for those that we consume, but there's no overlap between the foods and the cosmetics, because in Australia, foods are the ones that you consume, that you put in your mouth and you eat, and the cosmetics are only applied topically externally. So as I sort of mentioned earlier, the sunscreens may fall between in that grey area of cosmetics or therapeutic goods. So it can be cosmetic sunscreens or therapeutic sunscreens depending on various factors, but mainly the SPF being claimed for the product and the primary purpose of the product. So products with the primary purpose of protecting the skin from UV rays, they are classified as therapeutic goods and therefore regulated as therapeutic goods by the TGA. The cosmetic sunscreens are the products that are that have cosmetic effect, such as our moisturisers or the foundations. So a lot of those products that has cosmetic benefit, but also have secondary purpose of sun protection. So where the main purpose is cosmetic benefits, but it just happened to have additional benefit of sun protection. So those would include our sort of daytime moisturisers with SPF 15s that we put in the morning, or even those tinted bases and foundations with SPF. Those will be classified as cosmetic sunscreens, or the cosmetic products with sunscreen benefits. So then those products are regulated as cosmetics by NICNAS. So it's actually quite important to note the difference between the therapeutic goods and the cosmetics. So we'll be looking at the definition of sort of a cosmetic and a therapeutic good so that we can see what the main difference is between these two. And for those of you who are taking photos, I believe these will be circulated to you anyway. Yes, so it might save you some time. Okay, so what is a cosmetic product then? So in Australia, a cosmetic product is defined as something that is applied or in contact with external part of the body with a purpose to change the body odor or changing appearance, how we look, and also cleansing, as we all know, and maintaining in a good condition. So we are already all beautiful, but it just, maintains our beautifulness. And also perfuming and protecting from various factors. So, for example, protecting skin from the wind, chaff, dryness, and that sort of thing. So that's how the cosmetic is defined currently in the Industrial Chemicals Notification and the Assessment Act. So these products will include face and nail products, hair care and hairdressing products. Also, there's some of the oral hygiene products, like some of our toothpaste and mouthwashes, not all of them. And also, very obvious ones are perfumes, makeup products, a lot of personal hygiene products like deodorants, shaving products, cleansers, soaps, and various products that we probably use many times a day, every day. And also many of the skincare and makeup products, or I should say all of them, are regulated and classified as cosmetics. The therapeutic good is more broadly defined as a good that's represented in any way to be or is likely to be taken for therapeutic use. And that's how it is sort of contrasted to the cosmetic definition. So the main difference between the cosmetic and the therapeutic good is that Firstly, the NICNAS regulates the cosmetic products. NICNAS regulates the importation and the manufacture of the chemicals that's used in cosmetic products. And also the chemicals for human therapeutic use, so such as medicines, or if we want to sort of say they're listed complementary medicines or the OTCs, prescription medicines, they are regulated by the TGA. Some products obviously are used in a very similar way to cosmetics, but are actually regulated as therapeutic goods. And the typical example are the sunscreens that we usually put on when we go to the beach, not the sunscreens that you put just a tiny bit to keep your skin preserved from the UV rays. So the several factors that influence a product, whether the product is a cosmetic product or therapeutic good, includes mainly the primary purpose of the product. So what is the purpose of this product? What are people using these products for? And the ingredients in the products and how they affect the body, and also how the product is applied or administered, and also how the product is promoted, presented or advertised. So all of these products, all of these factors will be considered when you are determining whether a product is a cosmetic good or a therapeutic good. So I've got a definition of therapeutic good here and onto the next slide as well, but where I usually always draw attention to is this first one, the first 2 points, because they are the ones where it can often be sort of looked at and re-looked at multiple times to see, hang on, is this product that I want to claim that it's doing, is it really a cosmetic area, or am I sort of now moving into the therapeutic good definition, or am I claiming the therapeutic benefits? So we would always recommend everybody to re-look at the definition when you are confused about what you're claiming is a cosmetic or a therapeutic good. So cosmetics, as I mentioned, are regulated by NICNAS, and then they are regulated under the Therapeutic Goods Excluded Goods Determination 2018. This has replaced the Cosmetic Standard 2007, which was sunsetted in October when the determination came in force. So ultimately, what it really means is that the therapeutic goods, so if a product or cosmetic product meets the criteria in the excluded good determination, then it is excluded from being a therapeutic good, and therefore it is considered a cosmetic, or it should be presented and then promoted as a cosmetic. So that's ultimately what the therapeutic goods, excluded goods determination is all about. Whenever I put this determination wording in the slide when talking about cosmetics, everybody sort of, raised their eyebrow going, why are we talking about therapeutic goods when we're talking about cosmetics? But the whole idea is that it's excluded from the determination, being a therapeutic good. So as I mentioned earlier, NICNAS regulates the importation and the manufacture of the ingredients, the chemicals that's used in the cosmetic products. ACCC regulates the claims being made about the product or the cosmetic labelling information. And also, most importantly, if you wish to claim sunscreen benefits, the entire formula must have been tested as per the Australia and New Zealand sunscreen standard. And that means if a formulation changes, then you need to retest the whole formula all again against the standard to make sure that the SPF testing and the claim is met. So just looking at the cosmetics, then how do we know what ingredients are permitted in the cosmetic products? So the ingredients in the cosmetic product must be acceptable for use in cosmetics. That means they need to be included on the Australian Inventory of Chemical Substances, which is an online database maintained by NICNAS that has various chemicals to be used in Australia. And also, so you can check if your ingredient is on that database or not.
And also, if your ingredient is not listed on that database, then they are considered new chemical. Therefore, then there are other regulatory requirements that would be applicable for use of those chemicals in your cosmetic products. Sometimes there may be conditions of use in those particular ingredients that you are planning to use in your cosmetic products. So those might be specific conditions noted in the ARCS database, such as it may just say, oh, it's not too, the concentration in the formula must not be any more than 0.02%. Then that just means if your ingredient is less than 0.02%, then you're fine. The ingredient is considered to be on this database. But if you exceed that quantity, then it's just considered, it's not on my database, so therefore you are considered a new chemical. So that's all that means. Other restrictions that you also need to consider, and very important, is the poison standards. So this is a document that shows, outlines any restrictions or prohibition of using particular chemicals or ingredients in cosmetics or other products. But this document does show it is not the easiest document to read and understand. However, it does tell you all the restrictions and prohibitions for use in cosmetics. Other things is if a particular ingredient is considered sort of natural by the NICNAS definition, then they would be considered to be included on database by default. So sometimes a lot of cosmetic products these days use natural type ingredients or the botanical extracts for use in cosmetic products. Many of these, because they are quite new and botanical, they may not be on the NICNAS database. But if the way those botanical extract ingredients are made meets the definition of NICNAS definition of naturally occurring chemical, then they are by default considered to be included on the database, even if you cannot find it in that database. So the NICNAS definition of the naturally occurring is quite specific in a way, or could be broad depending on how you sort of see it, but they are pretty much looking at very unprocessed chemical occurring in a natural environment or extracted only by very minimal process, such as sort of mechanical or manual method or gravitational, that kind of very basic extraction methods. So if you have this plant extract ingredient that's not on the ARCS database, but if it does not meet this NICNAS definition of naturally occurring chemical, then it is considered a new chemical, and therefore regulatory requirements apply. So I've mentioned quite a few times about these new chemical, not on the database. New chemical, not on the database. So then what do we do with using new chemicals? So simply speaking, from NICNAS perspective, a new chemical is something that is not included on the ARCS database, so it's newly introduced to Australia. So that means you will be, because you're introducing a new chemical, so you would need to apply for a NICNAS notification prior to using these ingredients or importing cosmetic products with these ingredients. That may involve applying for a permit or certificate or qualifying for exemptions prior to use. There are a few different categories of permits and certificates and exemptions depending on the use and the volume and various factors. So some of the basic important things about the cosmetic requirements is that the NICNAS obligation must be met. So the use of the new chemical means that there are annual reporting requirements that will be applicable. So those, whether that will be under because you are using the chemicals under the exemption or the permits or certificates, annual reporting requirements apply. With the relatively recent reg changes that was introduced earlier this year, some permits and certificates don't require annual reporting anymore. And also the ingredient needs to be, so then those that need to be reported on an annual basis, they need to be reported to NICNAS by 28th of September. I always find this date quite interesting. It's not by financial year, it's not by calendar year, it's just 28th of September. And then the usage, the reporting period is captured from the 1st of September to the 31st of August of the following year. So you will need to notify NICNAS how much chemical you have introduced within that 1 year period by the 28th of September. Most interesting part, the claims. What can we say? So being a cosmetic, you can only claim the cosmetic benefits of a product. So then that will be so within the definition of the cosmetic that we've looked at. So maintaining the beauty, the good condition, protecting it, perfuming it. So it's within that level of cosmetic claims that you can make. And you, as a cosmetic, you cannot claim directly or indirectly any therapeutic benefits of a product. And all claims must be true, not misleading, and you should be able to substantiate the claims when you're asked to verify it, which I believe Michael will probably address a little more. So, and one interesting point is that the ACCC regulates, or they are responsible for looking at the cosmetic claims compliance and the labelling. But ACCC does recognise puffery claims, and then ACCC will not really expect you to hold evidence on file if you claim that your perfume is the best fragrance in the world or on earth. You definitely wouldn't be asked. So in terms of SPF claims, skincare products, so such as day moisturisers, can only claim up to SPF 15, no more than SPF 15. But tinted bases, foundations, and also the products intended for lips, they can claim more than SPF 15. So it would be anywhere between SPF 4 to SPF 50 plus, provided that you have the SPF testing report on file to substantiate that SPF claim. Now let's move on to the therapeutic goods then. We've had now enough look at the cosmetics. So most therapeutic sunscreens are listed with the TGA. There are some that's registered on the TGA, but that would involve, those registered sunscreens will involve a little more than just claiming sunscreens as a primary purpose. So because these therapeutic goods, primary sunscreen products as a therapeutic goods are regulated as a medicine, the ingredient used in these therapeutic sunscreens must be acceptable for use in medicines. So unlike cosmetics, they must also be manufactured at a TGA-approved GMP facility. And for overseas manufacturers, this would mean that their GMP status would need to be assessed by the TGA and approved by the TGA before they can manufacture and supply those therapeutic sunscreens in Australia. And for Australian manufacturers, it will just simply mean that they need to be TGA licensed manufacturers. Just like cosmetics, the SPF testing for therapeutic sunscreens also must be done as per the Australia and New Zealand sunscreen standard. But being a therapeutic good, there are many other testing requirements that's applicable to a medicine. In terms of labelling, the TGA will be regulating the label compliance, and the content of the label must comply with the medicine labelling order, which will be the TGA 9E2. And unlike cosmetics, currently, certain types of the advertising material needs a pre-approval before they can be used. So just looking at the ingredients that's then used in these therapeutic sunscreens, as I'm talking about the listed medicine type therapeutic sunscreens, these ingredients must be acceptable for then use in listed medicines. So that means these ingredients needs to be included in the therapeutic goods permissible ingredients determination. I know there's number 2 written there, but number 3 was just introduced a couple of weeks ago. I believe when it's circulated, the link actually goes to number 3, although it says number 2, apologies. And also the active ingredients used in these therapeutic sunscreens must be permissible and listed as an active sunscreen in this determination. So in this determination, what you will see is a list of various ingredients that can be used in listed medicines. Just for the sunscreens, the determination will specify that particular ingredients are permitted for use as a sunscreen active only. So only those ingredients that's noted as a sunscreen active can be used in the therapeutic sunscreen. If your ingredient is not in this determination, then you can apply for your ingredient to be assessed and added to the list, but it is a relatively long and costly process. In terms of the claims you can make for therapeutic goods, because they are listed sunscreens, they are therapeutic sunscreens, in terms of therapeutic claims, you can only claim sunscreen-related benefits. And currently, the TGA products and the listed medicines are only allowed to claim therapeutic claims based on that's listed on the permissible indications determination. This determination is updated about 3 to 4 times a year, and then there are a list of over 1,000 indications just for use in listed medicines, and some are specifically listed for sunscreens. We are probably one of the countries that allow the word cancer mentioned for the sunscreen products. There is a minimum SPF level requirements for some of these sunscreen indications. So, for example, may assist in preventing some skin cancers and reduce the risk of some skin cancers. I believe these indications are permitted if your therapeutic sunscreen is actually more than SPF 30 or SPF 30 and SPF 30. Currently, some of the existing listed medicines, all of the existing listed medicines need to transition to the new system of using only these permissible indications, because in the past there were free text areas where you can write any claim that you want to have for your product, provided that you have evidence for it. So just to sort of give you a summary and some of the take-home messages for today's or this presentation is that the therapeutic sunscreens must be listed or registered with the TGA, and also only the list of permitted actives can be used in the therapeutic sunscreens. It's important that it's tested as per the Australia and New Zealand sunscreen and also various TGA standards, being a therapeutic good. And also it needs to be manufactured at a GMP level that's acceptable to the TGA, and also a full product specification with the good formulation details would be expected to be on file too. And the label must be as per the medicine labelling, and pre-approval is required for some advertising currently. And you can only make, as a listed therapeutic sunscreen, you can only claim sunscreen benefits, no other therapeutic benefits. And for cosmetic sunscreens, only cosmetic ingredients would be permitted, those that I discussed earlier about being on the ARCS and not restricted by poison standard. And as cosmetic, just same cosmetic labelling requirements apply even if it's a cosmetic sunscreen. And of course, the Australian and New Zealand sunscreen standard testing requirements apply. We have highest skin cancer rate, and plus apparently overseas beauticians and the dermatologists are not very fond of people who came from Australia for treating or removing any sunspots on the skin with the laser. So no more than SPF 15 is permitted for the skincare products, but tinted bases and foundations or products for lip products can claim more than SPF 15 and must be presented as a cosmetic with secondary sunscreen benefit. And that's it for today from me. And I'll now pass on to Michael to address the even more important and interesting part. Thank you.
Thanks, Ellie. Okay. So Ellie's presentation was really focused on the differences between the NICNAS regulatory regime and the TGA regime. And one of the things that Ellie mentioned was that there are a few factors that are taken into account when you're trying to work out whether or not you fall within the NICNAS regime or the TGA regime. And one of those things was about whether or not, or it was really just about the way that the product is marketed and the claims that you make in respect of the product. So I thought it would be good to, rather than sort of rehashing the TGA and the NICNAS regimes, I thought I'd introduce another regime, and that is the Australian consumer law, just so that we could focus then on the claims that might be made about sunscreens and how that will impact on the way that you market and supply your product in the Australian market. So a couple of things that I wanted to talk about today set out on this slide. So I'm going to give a quick overview of the regulatory regime. I will then talk about the Australian consumer law, and there's a lot of law in the Australian consumer law, but I'm just going to really focus on two things. Firstly, misleading conduct, and then consumer guarantees, and look at how they impact on the claims that you might make about your sunscreen product. I'll then look at what happens if it all goes wrong, or what happens if you get it wrong. So what are the penalties and what other sort of remedies are available to the regulators? And then I'll finish off with just some practical tips. Okay, so overview of the regulatory framework. So Ellie, as I mentioned before, sort of mentioned about the NICNAS and TGA framework, and I'm sure that a lot of you probably appreciate the complexity of those regimes. There's a lot of law, there's a lot of regulation, a lot of determinations, a lot of information out there about what you need to do and what you need to comply with. But I thought it would be good just to emphasise that by listing some of the things that you need to take into account. For example, the Australian standard on sunscreen products. And I'm not going to go through all of these, but I just want to, the list is here more for effect than for me to go through it in detail, but there's even more, as you can see. And then if you're going to, and this is all about the regulatory regime in as far as TGA and NICNAS is concerned in Australia, but if you're looking then to market a product overseas, then there's obviously overseas regulations and things that you need to think about. And there's, I'm not quite sure why this is happening, but anyway. I'll have to click it about 3 times to get this up. But there's, you know, other regulatory regimes as well. So I'm going to talk about the relevance of the Australian consumer law. And as I mentioned before, I'm really just going to talk about a couple of things. One is misleading conduct, and the fact that as suppliers of a sunscreen product, you need to make sure that you're careful about the claims that you make, and you also need to make sure that you have evidence to substantiate those claims. And those claims might be claims that you make on your packaging, on your labelling, in your advertising of the product. And the other area that I'm going to talk about, as I mentioned before, is just around the fact that there are these minimum quality standards in the Australian consumer law. So there are consumer guarantees that apply to any consumer product, which is basically any product that is sold for personal, household or domestic use. So obviously applies to sunscreens. First of all, misleading conduct. And there's 3 main provisions of the Australian consumer law that I want to talk about. Firstly, Section 18, so there's a general prohibition on businesses engaging in misleading and deceptive conduct. There's Section 29, which prohibits organisations or suppliers from making false or misleading representations about the quality or the performance of a product. And there's also Section 33, which is probably less well known than the other 2. So the other 2 get mentioned quite a bit in presentations like this, but Section 33 is there as well, and it basically prohibits conduct that's liable to mislead the public as to the nature of a product or the manufacturing process of a product or the characteristics of a product. Now, all these provisions all deal with misleading conduct or misleading representations that are being made. There's no definition about what misleading is in the Act. So it's not defined, but it's really just the overall impression that is created by the conduct in question. And the threshold test is really, whether or not the overall impression of the conduct induces or is capable of inducing an error. And that's an error that's determined on the part of the consumer. So if there's conduct or a representation made that is likely to induce an error on the part of the consumer when they're buying your product, then it's probably misleading conduct or a misleading representation that's been made. It doesn't matter whether or not there's an intention to mislead, so intention doesn't come into it. It's just a question of fact. Has someone been misled, or are they likely to be misled? And the person that we're talking about is the person to whom the conduct, who's affected by the conduct. So in the case of sunscreen products, it would be the consumer. And the consumer is just going to be determined by what we call in the legal world as the reasonable person test. So it's just a reasonable person going about normal business. They don't have any assumed knowledge about a product. They don't have any, degrees, or they're not in the industry. And that's probably one of the areas where, as suppliers of cosmetic products, you need to just be careful to make sure that when you're looking at the claims that you're making, that you're not taking into account that you're sort of removing that assumed knowledge that you have. So you need to look at the claims that you're making through the eyes of a consumer. A leading case on this particular point is the Neurofen case. And it's a few years old, and I'm sure that most people have probably heard about this case, but it actually is a really good illustration of what not to do. Okay? Years ago, Reckitt Benckiser had a number of Neurofen products which it released onto the market. And they made a number of representations about these products on their packaging and on their websites. And they basically purported to claim that these products had targeted 4 different types of pain. So they were targeted towards migraine pain. They had a product for tension headache pain, a product for period pain, and a product for back pain. And I've got some images of the packaging here just to show you. And you can see as I go through that, one of the main differences is the colouring of the packaging. I'm going to see if I can get this laser thing to work. Yeah, okay. And you can also see that each pack has the indication of Neurofen on there. And then just beneath Neurofen, it specifically refers to the particular type of pain that it purportedly is targeted towards. That appears on the other packaging as well. But another thing that's not quite so clear to you, but I assure you that it says here, fast targeted relief from pain. So it makes a claim about targeted relief. And also on the back of the packs, it also had some wording there that was also interesting and sort of just reinforces that targeted relief of pain message, because it talks about how the product is fast and effective in the temporary relief of pain associated with, and then it would say the period pain or tension headache pain, that kind of thing. So while Reckitt Benckiser promoted these products as 4 different products, there was no real difference in the actual product itself, because the active ingredient was the same in each product, and that was 200 milligrams of ibuprofen. And the only differences then were really just around the colouring and the indications on the package, or the fact that it said targeted relief for back pain or period pain. And another difference was the price of the product. So the price of the product for these targeted pain products was about twice as much as the normal Neurofen product. And the normal Neurofen product, its active ingredient was the same, 200 milligrams of ibuprofen. Contrary to those representations, ibuprofen doesn't actually target any particular type of pain. So it actually treats all types of pain in exactly the same way. So to claim that a product where the active ingredient is ibuprofen is capable of targeting pain was misleading. And that's basically what the court found. The court basically found that the claims that were made in respect to the products were that each product could target particular pain, and that also that the product would actually target the pain and treat the pain when in fact all the products were the same. Another interesting thing that I read about this case was that even on the ARTG approved indications for each product were exactly the same. So it was quite bizarre that they thought it was a good idea to make these representations and claims that the product could actually target different pain. So anyway, ultimately they ended up with they admitted that they had contravened sections 18 and 33 of the ACL, and they were fined $6 million in order to pay costs for the regulator, and they would have incurred their own legal costs. So it was quite an expensive mistake on their part. Another case which I'll just quickly mention, mainly just because I thought it was really bizarre, but it's also just a really good illustration of, or gives me a chance to talk about the need to substantiate your claims. And this is a claim just involving a company called Purple Harmony Plates, and they basically had some anodised aluminium products which were sort of just sheets of anodised aluminium, which apparently had some really good health benefits, right? And as you can see here, I've sort of indicated some of the things that they claimed that these bits of anodised aluminium could do. They could reduce pain, they could treat burns and cuts, and also give you, strengthen the immune system. Here's a couple of the actual claims that they made. If you put a glass of water on an aluminium plate, wrong button. Bear with me. That's good, I just ruined my punchline. But anyway, there's, the water's energised by the life force energy. So there you go. Or if you put your computer on one of these, on these plates, then you could work in a 3 feet bubble of positive energy. So anyway, the ACCC came along and they asked them, can you substantiate these claims? Well, they couldn't. But what they did come up with was a couple of testimonials from 2 customers, which made these testimonials after sale, of course, saying how happy they were that they bought the product. But obviously the court said, look, that's got no real value when you're looking to substantiate the claims made. It needs to be something more than that. And obviously they got fined and they were imposed a whole heap of penalties on that company. So what do you need then to substantiate claims? So if you're going to make the claims, you need to have some evidence, you need to back it up. And the answer to that question is really depends on what is your product. And so is it a TGA product, is it a cosmetic product? Because there's different requirements depending on which regime you fall into. If you fall into the TGA regime, then there's a bunch of guidelines that the TGA publish. For example, there's guidelines about the evidence that you need to substantiate claims about complementary medicines. When it comes to sunscreens, there's the Australian regulatory guidelines for sunscreens, and there's also an Australian standard 2604, which sets out some of the requirements for testing of products, determining the SPF, the water resistance of a sunscreen and that kind of thing. So that there are publications out there that give you some guidance in that respect. But if you don't fall within those regimes, then it really just comes down to some common sense stuff. Things like surveys, things like clinical trials, academic papers, all those sorts of things about the ingredients. They don't have to be things that you have done. I mean, obviously, if it's your product and you've made that product, then obviously testing it or having some kind of paper or scientific research done on the product is a good thing, but it's not mandatory. There's ways of being able to show that an active ingredient will work in a particular way without necessarily having to test it yourself. So you can rely on other people's research. But it is really just important to make sure that you have that body of evidence there and that you have a product dossier that has all those things in it so that if the regulator does come knocking, then you have something ready to present to them. If you're a distributor of someone else's product, so it's not uncommon that you might import a product and you distribute someone else's product, then you should be asking the supplier for evidence of the claims that they want you to make in respect of the product. So that's misleading conduct. Consumer guarantees. There's 9 consumer guarantees that affect goods that you sell. There's guarantees about title. That means that you're going to give the customer good title to the product when they buy it, that they're going to have undisturbed possession. And there's a bunch of these guarantees, which I won't talk about all of them, but I'm just listing them here for you. But I wanted to talk about a couple of these because they can affect or they can arise as far as being things that you might infringe if you make claims about a product and you get it wrong. One of those areas is acceptable quality. So as a supplier of a product, you give a guarantee to the consumer that the product will be of acceptable quality. And that means that the product will be fit for purpose, that it'll be acceptable in appearance and finish, that it'll be free from defects, safe and durable. And when determining whether or not a product is of acceptable quality, one of the factors that is taken into account are the statements that you might make about the product, whether on the packaging or the labelling, and the representations that might be made about the product by the manufacturer. So you can see that the claims that you make might impact whether or not you fall foul of this consumer guarantee, because if you make claims about a product that turns out not to be true, well then this guarantee, you'll breach the guarantee. Similarly, there's a guarantee about fitness for purpose. And so again, if you're making claims about the product, for example, that it has SPF of 30 and it actually only has SPF 15, and that kind of thing, well then it might not be fit for purpose. There's also a guarantee that the goods will match a description of the product that you might give, or it might match the sample of a product that you've given. And again, so it depends on what the claims you have made about the product. And if the claims aren't correct, then again you might be in breach of one of these guarantees. A case involving a sunscreen product and infringement of consumer guarantees is this case, the Origo case. Origo was a supplier of a broad range of different products. They had a number of stores in New South Wales and Victoria. And for a period of about 6 years, the inspectors from Consumer Affairs Victoria visited their stores. And that kind of thing does happen. So inspectors from ACCC and inspectors from the regulators do sometimes visit stores. And they go and buy products, or they seize products if they think that the requirements aren't being met in respect to those products. In this case, they seized a bunch of products. Some of those products were children's toys, which didn't have appropriate warnings on them, luggage straps, cosmetics that didn't list the right ingredients, all those sorts of things. But they also found some products which were being sold as Sunblock. And some of you will know that the term Sunblock, and I know that that was a product that Jason had a video of, Sunblock 5000, but Sunblock, using that expression Sunblock when it comes to sunscreens is a no-no, because sunscreens will filter harmful rays, but they don't block them completely. And so calling a product Sunblock is not permissible. And so Origo was selling these products, Sunblock, and they obviously were found to be engaging in misleading and deceptive conduct because they didn't comply with labelling requirements, they didn't comply with the advertising code, the Therapeutic Goods advertising code, they didn't comply with the Australian Standard 2604, which relates to sunscreen products. As a result, they were fined. They had a fine of about $350,000. They had to enter into a compliance plan, and they had to publish some corrective notices and other things and give refunds to customers and that kind of thing. So it was quite painful for Origo. And this brings me to, what happens if you do get it wrong. So I've just spoken very briefly about 3 cases, and that should give you a bit of a sense of what can go wrong and some of the penalties that can be imposed. But I just wanted to explore this a little bit further. You might have a product, for example, that has a primary use as a moisturiser or a lip balm, that kind of thing, and it might have that secondary purpose as being a sunscreen. Maybe it has, it's got some ingredient that gives it an SPF factor. If you fail to adhere to the requirements, right, so if you get it wrong as far as determining whether this is a cosmetic or a therapeutic good, then you might be making claims about your product which are unsubstantiated. You might be making claims about the product or saying that they have an indication which is not permissible under the requirements, and the product might then be treated, rather than as a cosmetic, it might be treated as a therapeutic good. And if that happened, well, then you'd be in breach of a whole heap of requirements under the TGA Act, including things like the registration of that product or the listing of the product on the ARTG, using the permissible indications, and there's a whole list of those areas where you could fall foul on this slide. That in turn means that you'll come under the notice of the regulator, because that's something that can happen, and then obviously the regulator might look at your other products as well. So even though you might just have that sunscreen wrong, but they'll start looking around at the other products that you have. So it can be quite not a good thing to sort of come under the eye of the regulator. But what does that then mean? What are the kind of penalties that would be imposed? And I mentioned before that there's a couple of regimes where penalties can be imposed. And I'm just going to talk a little bit about the ACL contraventions, because if you get it wrong as far as the Australian consumer law is concerned, then there can be penalties of up to $500,000 for individuals. It can be even more for companies, so it can be up to $10 million or 3 times the benefit or 10% of your annual revenue. So that's quite a big fine. And obviously, this is at the extreme end. This is the stuff, the maximum penalties that can be imposed. But there's also a bunch of other remedies, like injunctions and corrective notices, product seizures, product bans, compensation orders, all these other things that can be imposed as well. Similarly, under the TGA Act, if you contravene the TGA, then depending on what provisions of the TGA you contravene, then there's very similar kinds of penalties. There's civil penalties as high as $1 million for individuals or $10 million for companies. So very similar to the ACL. And then again, there's a bunch of other remedies that can be imposed by the TGA, like issuing education letters or direction notices, infringement notices, public warning notices, which means that you have to go out and you have to warn your customers about the products that you've sold them. It could be injunctions to stop you from continuing to contravene the Act, or recall a product. You can be suspended from having the product listed on the ARTG, or additional conditions might be imposed on that listing. So there's quite a lot of things that can happen if you do get it wrong. And the specific penalty that might be imposed will really just depend on these factors. Right? So often people come up to us and say, look, what happens if I get it wrong? What's likely going to happen? A lot of the regulators don't necessarily issue fines straight away. They usually look into it and they'll usually give the organisation an opportunity to rectify it if they can. But if it's a matter of public safety, then they will usually come in hard and they might expect you to withdraw the product, right, from the market. But imposing fines and other things like that, they don't just do necessarily straight away. So they'll try and work with the supplier to see if they can rectify the situation. But the kinds of penalties will really depend on these things. You know, like how many times have you contravened the particular section that you've contravened? How severe was that contravention? Like, what's the impact on the public? Is it a public health issue? Have you contravened the acts before? Do you have a compliance program in place? You know, do you educate your staff about these things? And what level of cooperation you have with the regulator when they come knocking on your door? Just some practical tips. Ellie kind of mentioned this before about when you're assessing your product as to whether or not it's going to be a cosmetic or a TGA product. You need to think about the primary use of the product. What's the primary purpose of the product? Is the sunscreen just a secondary use or is it the primary use? Think about the way that the product is applied in the market or how you want it to be applied by the consumer. You've got to think about the ingredients that are being used, because depending on some of the ingredients that you use, it might bring that product from cosmetic into therapeutic. And then you also need to think about the marketing of the product and the claims. And that's, I guess, been the basis or the thrust of my presentation. I also suggest that you look at putting in place a robust compliance program. I know that most organisations who sell these types of products have compliance programs in place. You just got to make sure that you educate your staff and document your compliance program so that if the regulator comes knocking, then you can show them, look, we have a compliance program and this is what we do. Coming to these kinds of presentations, you know, would help. Another thing is like regularly monitoring the TGA, NICNAS and Standards Australia websites for new developments, because it has been changing. Nellie kind of mentioned that only just a couple of weeks ago there was a new determination issued. So it's keeping up to date, making sure that your business stays up to date with some of those things. Also having internal marketing policies in place, because as I mentioned, I guess, you know, the thrust of my presentation has been about the claims that you're making. And we often see with our clients that often, you know, it's really just the claims that are being made about the product that are causing the, you know, sometimes the problem. And it's always this tension between marketing the product, because usually people want to push as hard as they can on the marketing, because you're trying to induce people to buy the product. Yeah, and you just got to balance that off with you know, making sure that you're not overstepping the mark. That might then bring you into TGA land. And lastly, you know, when in doubt, then you should seek, you know, go and get help if you need to. And that's basically it for me. So happy to take questions. Thank you. Yeah, if you want. Does anyone have any questions? Yeah, okay. Yeah, sorry, we're recording it, so it'd be great if you could.
So that one with the aluminium thing.
Yep.
And they relied on like 2 reviews. What would happen in a circumstance where say it was on Amazon and they had 5,000 5-star reviews?
I think they would probably still need some kind of scientific evidence to back up. Yeah, I don't think just a consumer review saying, yeah, this is great, this helped me. I think you would, if you're making that kind of health type of claim, then...
What if they hadn't really made any claims, but the people have gotten on and through their reviews they've gone, oh, you can do this, this, this and that, and then other people had read the reviews and suddenly this product then gets notorious for something that's completely sort of unsubstantiated?
I think...
Does that fall back on the...
Yeah. Well, as long as the supplier's not representing that. Now, that being said, misleading conduct can be silence, right? So by not saying something can be misleading as well. So if there was a groundswell of, public opinion that said that, this had a therapeutic benefit or some health benefit when it didn't, then I think you would have to come out and say, look, it doesn't, or we don't know, we don't have the evidence. Yeah, we can't substantiate that claim, or we're not making that claim. Yeah.
I also have a question around the electromagnetic field products, because electromagnetic fields and their effects, there's no proof that they're real, right? They're all psychosomatic, so you can't really prove that any product will stop that effect, yet I have seen a lot of products on the Australian market in that category. Does that mean they're all in breach?
Right. Okay. Yeah, they probably are. I don't know. I can't comment. Any? Yep.
Yeah, question for Ellie around licensing. Manufacturing of sunscreens, is that a separate section on a TGA license, or if you are licensed to manufacture listed semi-solid lotions and creams, you automatically qualify to manufacture sunscreens?
Yes, you would automatically, likely. I can't say 100% because I'm not sure exactly what you're talking about, but just listening to what you're saying, if it's a TGA licensed manufacturer for the dosage form that's used for the sunscreens, then yes.
You were saying earlier that it has to be a GMP manufacturer approved by the TGA.
Yes.
What if the product is made overseas?
If the product is made overseas, let's say it's a therapeutic sunscreen, so you want to bring a listed medicine, then that overseas manufacturer's GMP needs to be evaluated, assessed and approved by the TGA. So there will be an application process. Partly yes, it actually depending on where the manufacturer is. So for example, if it's a US manufacturer, then it is highly likely in most cases that the TGA will actually physically go and inspect. And then there are other paper-based applications as well. Or if the manufacturer is in a country that the Australia TGA has MRA with, then it will be a different type, more easier type of paper-based application where the overseas GMP certificate is submitted to the TGA for the assessment and approval.
So like a European standard would be accepted?
Many of the European GMP certificates are recognised as an MRA with the TGA. So on TGA website, they actually do have a list of specific overseas regulators that TGA recognises as an MRA with, mutual recognition. Then those ones will sort of go through the easier or simpler process in terms of approval.
Great. Any more questions? If not, please join us for some refreshments afterwards. Or is that what you were going to say, Jason? Sorry.
Taking my job, jeez. Everyone, I think we've all been very well informed tonight. And I remember some years ago when I was doing some work for Hyundai, the marketing people said, why should the law get in the way of good marketing? And we clearly know why. And they even got pinged for that little baby campaign they had several years ago. So, the marketers always want to push the boundaries and sell product, but, within reason. But once again, I want to please thank Ellie and Michael for their presentation tonight, and then please join us up the back for drinks and some more.